All right, let's spin this back now and see what kinds of things could have been done a little bit differently. Coulda, woulda, shoulda. Would planning have helped? You betcha. But first, let's do a little homework so that some of the suggestions that I have might make a little more sense. Let's talk a little bit more about Medicaid. There are three ways, basically, you can pay for the nursing home. One is private pay. If you're one of those 1%ers and can sit down and stroke a check for 10 grand a month, good on you. There's insurance, but as I said, most people don't have nursing home insurance. And then there is Medicaid. It's hard to qualify, and it's very easy to make mistakes without help. That's why I hope people will consider seeking knowledgeable help. I have had many people come into my conference room here and talk to me about what's been going on the past year, and inside I'm just groaning at the amount of money that they have spun through without knowing that they really didn't have to. Okay, there's three basic concepts when it comes to Medicaid. And as I tell my clients, if you can keep them separately in your head, you'll have a little easier time getting through this. First of all, there are the asset rules. Those are the rules that just have to do with getting onto Medicaid. How many assets can you have? Then there are the transfer rules, which in a perverse sort of way actually makes sense. The transfer rules are there because if they weren't there, anyone could qualify for Medicaid simply by giving everything away and going down to DSS and applying for Medicaid. So the transfer rules say that for certain amounts that you've transferred within 5 years of applying for Medicaid, there will be a Medicaid sanction, a period of time that they will not pay for the nursing home once you've been determined to be otherwise qualified for Medicaid. And then finally, we've mentioned this, they're the estate recovery rules, and we'll talk about each one of these in a bit more detail. But the estate recovery rules basically says Medicaid is going to come back against any assets left in the deceased Medicaid recipient's estate to see if they can't get themselves paid back in some form or fashion, or at least partially. All right, let's talk about the asset rules. Many assets count under strict government rules. A married couple can keep more assets than a single person who is trying to qualify. And I'll mention this a couple of times. There are actually quite a number of strategies that a married couple can pursue. It's still hard work, but for someone who knows what they're doing with these rules, it's relatively easy to get one half of a married couple onto Medicaid. That single person, on the other hand, I'm going to have a real tough time with because there is an asset limit, a countable asset limit of just $2,000. For the married couple, at least in 2020, it's $128,640, and we'll talk about spend down and everything like that in just a moment. So, how does Medicaid treat trusts? Well, first of all, if it's a revocable trust, and I do use revocable trusts in my planning, and it's a very deep subject, and I'm not going to be able to get into it in too much depth here. I'm merely mentioning that because if you're a current client of mine listening to this and you've heard me say revocable trust isn't going to help you much, don't panic, because you've probably got one of my plans in which I actually do use a revocable trust. But generally speaking, if you have a revocable trust that someone set up for you to avoid probate, everything in that revocable trust that would otherwise be countable is going to be a countable asset. And of course that makes sense because they're going to look at you and say, just go down and take it out of the trust. The trust is revocable. What about an irrevocable trust? Well, it depends. If either Don or Jean set the trust up while they were alive, they look at where the assets came from. The assets in a trust that Don and Jean set up while they were alive, if it's irrevocable, Medicaid is going to count the assets in the trust if there is any way whatsoever that the trustee could make a distribution. As I like to tell some of my clients, if the trust says, if the sun comes up in the West on a purple colored day of an even numbered year, the trustee can make a distribution. Medicaid's going to count the assets in that trust because after all, there is a conceivable way, no matter how far-fetched, that distributions could be made. I call that the any circumstances rule. And to the extent that there are any circumstances that a distribution can be made, they're going to count those assets that could, under any circumstances, be distributed. On the other hand, if income could be distributed from the trust, well, they're going to count the income, but if the trust said don't ever distribute any of the assets in the trust, like principal, like land, investments and the like, don't ever distribute that to mom and dad, but distribute the income to them, well, then they're going to be in pretty good shape. And guess what? Even if they had put the land in the trust, they could still go out there and use the land, do whatever they were going to do with the land in any event. One big break, though, that we get, and I tell folks, when I'm used to them throwing hard balls at me, I'm not going to complain when they toss me a beach ball. If one of Don or Jean is deceased and the trust is in a will, if it is a trust that it was set up under a will, then the principal doesn't count. The only thing that's going to count is anything that does get distributed to the trustee. They could keep use of the assets in there, but the only way that the assets in that trust under a will, called a testamentary trust, is going to be countable is if the trustee has a legal obligation to make distributions. So if the trust under a will says, trustee may, within his sole discretion, decide to make a distribution to the surviving spouse, the assets in that trust will not be counted. Now let's talk about transfers. I mentioned a little bit about transfers. What happens is if you made a gift, that's a transfer that was not for fair market value. If you made a transfer that was a gift or even partially a gift, and the transfer was not one of the exceptions, then the value of that transfer is going to generate a sanction for you if you apply for Medicaid within 5 years of making that transfer. If you made the transfer 5 years and a day ago, you're okay. If you made a transfer 4 years, 11 months, and 28 days ago and got some very bad advice and went down and applied for Medicaid right then and there, you're going to have a transfer penalty. So what about this irrevocable trust that you set up while you were alive? Assets transferred to that trust will not be countable. But here's another big gimme. Transfers by will not generate a transfer sanction. I don't know why Congress was so in love with wills. Trust under a will, good. Transfers by will, good. Give you an example. By the way, to generate the transfer penalty, they will divide the amount of the transfer by $6,810. That's the average nursing home Medicaid reimbursement rate for a nursing home in North Carolina. I don't know where they came up with that number. So let's give you an example. If I transferred $68,100 to my son, and then a few months later, a few years later, within 5 years, my wife went into the nursing home and applied for Medicaid. Once she became eligible for Medicaid, they're going to take that transfer, $68,100, divide by 6,810, and say, you've got a 10-month transfer penalty. Whereupon she's going to say, or my son's going to say, what do we do now? And Medicaid's going to say, you should have thought about that at the time. So instead, I got smart. I did a will. I followed my own medicine. I did a will, and in my will it said, I want my son to get $68,100. And then I die. And my executor calls my son up and says, son, your daddy wanted you to have $68,100. Come on by the office and pick up the check. The next day, my wife went into the nursing home, grieving her heart out, went into the nursing home and applied for Medicaid, and guess what? That transfer didn't make any difference at all because it was a transfer by will. Transfers by will, good. Trusts under a will, good. Now, what are some of the exceptions to the transfer rules? Well, first of all, transfers to a spouse. Husband and wife can transfer assets back and forth to their heart's content. There's no transfer penalty. Transferred to a disabled child. But be careful, because if that disabled child happens to be on Medicaid or SSI, you're transferring assets to that child could cause a lot of trouble. There are, by the way, certain types of trusts, be a subject for another program altogether. It gets rather complex. But there are certain types of trusts that I can set up for the disabled child, and the spouse can transfer, or a transfer could be made into that trust for the disabled child, and it wouldn't be a sanctionable transfer. In fact, I could set a trust up for any disabled person under age 65 that you could transfer to. For example, grandparents. They can't just outright transfer assets to a disabled grandchild because the grandchild isn't their child. It's a grandchild. But a certain type of trust could be set up for that grandchild, and the grandparents could make a transfer into that trust without incurring a transfer sanction. And then, of course, as I said just a moment ago, transfers by will are exempted from the asset transfer rules. Let's talk about estate recovery. Assets in a deceased Medicaid recipient's estate can be taken by the government. What's going to be in the deceased Medicaid recipient's estate? Invariably, it's going to be the home. And if steps weren't taken to protect the home, it's going to be available for estate recovery. Or if you own property with someone else, it won't count for Medicaid purposes, but it's certainly going to be there for estate recovery, and that other property owner is not going to be too happy about it. There is a big exception. No estate recovery if there is a surviving spouse. Let me let you in on a little secret. Recently, within the past year, the North Carolina Division of Health Benefits started saying, oh, we're only going to defer estate recovery for the surviving spouse or the disabled child. And they have no basis in the law at all for saying that. They have no way of enforcing it. There's not a thing they can do. If you look at the North Carolina statutes, the statutes say no estate recovery if there's a surviving spouse. You can't just make up the rules on the fly. So don't worry about that if you hear that they're just deferring, because they have no way of enforcing it. It might be years later before the surviving spouse dies. They don't have any mechanism for putting liens on property or anything of the like. In fact, some years ago, the General Assembly came out and actually struck down a bill that was sponsored by some folks in Raleigh that would have allowed for liens, and General Assembly said no way.